Good evening, this is Rahul Reddy. Reddy Neumann brings immigration news every week on Tuesday at 5 p.m. Central Time. Along with me is my business partner. Emily, on the H-1B selection right now, we do have the things that say selected, that everybody knows that their H-1B is selected in the lottery and they can file the application starting from April 1st all the way to June 30th. Now, there is something called submitted right now. Does that mean for the people who are submitted, do they have a chance of getting selected? What do you feel about that?
So, there's a chance, I suppose, that...
Or is it 99% chance?
Very, very low chance. Based on everything we're seeing right now, I think everybody's that's been selected, they already see that they're selected. It does not seem like the government is still updating. I've been reporting on my blog that I have not seen any new updates since Saturday afternoon. I checked it yesterday twice a day, checked it this morning. I'll be checking it one more time before I leave today. So I think that they're done informing people. Now, for those that are submitted, they'll stay submitted through the end of the fiscal year, which is technically September 30th, 2021. So if for some reason the cap doesn't get filled based on what they've selected so far, yes, they've left the door open to do a second lottery. Is that likely to happen? Probably not, unless something, crazy. These are crazy times. You never know with the coronavirus.
Even if it does happen, though, the chances, if your case is submitted, for you to get through that, because even if some people who have been selected drops out, the USCIS has already considered some cases getting denied, some cases is getting dropped out. So there is very slight chance. Would you say it's less than 5%, Emily?
Yeah, probably less than 1%, I think.
Less than 1% or less than 5%. So, and can they now, if it's submitted, are they eligible for cap?
No.
So they're not eligible for cap.
No.
Okay. So Emily, on the 60-day grace period, is it extended? There are so many rumors flying out, and some people are making money on it. Mm-hmm. So asking donations, hey, here is where it is. Is it extended right now?
No, it's not. It's really important to know, because I'm getting asked that all the time. People are saying, well, I heard, and some people are saying they've heard this from attorneys claiming that everything is relaxed. There's no enforcement happening right now, and nothing's going to happen if you fall out of status. That's completely false. Every single regulation for skilled worker visas, H-1s, L-1s, O-1s, TNs, every single regulation remains the same. There has not been one thing that's been relaxed except for scanned signatures can be submitted to USCIS.
And the RFE response time has been extended.
Everything else is still, you have to comply with it. So there's no extension of the 60-day grace period, even though other countries are extending visas automatically. We're not doing that here. So please be very careful about following.
I understand some of the immigration lawyers saying that, okay, my visa is expiring. Now I need to leave to India. How do I leave? Yeah, well, they may be indicating that you could stay unlawfully here. What else can they say? Could they tell you, okay, now you start swimming from New York to Bombay with a swimming suit on? I don't think so. That's even legal, even if it's physically impossible. So yes, the lawyers might suggest that don't die. You're better off staying unlawfully. They may be suggesting, and I can't blame them, of course. So there are some issues that if a person is unlawfully present in the country for less than 180 days, you won't be, you can still apply for the non-immigrant visa when you go back. Under the current situation, though we are under legal force, we have been legally forced to advise you not to stay unlawfully, but can we advise you? Well, go swim across from New York to Bombay? No, we won't advise you. So if you are unlawfully present in this country for less than 180 days, you are still eligible to apply for the non-immigrant visa, but you still need to mention that you were unlawfully present here. we are sure that the consulate will understand why on a March 31st you did not took a swimming suit and started swimming from New York to Bombay. They will understand it very clearly. I mean, this must be inhuman for them not understanding. But as far as Emily is pointing out is that the regulations and rules have not changed. The only thing that has changed is the RFEs can be filed, RFE responses if there is a deadline can be done. They're not going to stick with the deadline. They're going to allow it until June 30th right now. Is it right, Emily? June 30th?
60 extra days.
Yeah. I'm sorry?
60 extra days.
60 extra days to get
RFE
into
response.
it. And then if there is a signature required, you can file an application without signature, especially when people are going out of status. We are doing that. We get the forms, scanned it, and we just put it there and file it, and the USCIS is going to honor them. Anything else on that, Emily?
No.
Biometric notifications that were being issued for the H-4 and L-2s. Now, biometrics are needed for every non-immigrant, most of the non-immigrant visa extensions, including E2s, O2, including L2s, H4s, and other non-immigrant visas, except H1s and L visas. What's going on with the biometrics appointment?
So yesterday there was an announcement from USCIS saying that if you are filing your I-765 renewal application and USCIS already has your biometrics from your last application, they will use the old biometrics to process the I-765 so they can still issue them. The problem is the biometrics requirement for the H-4 EAD and the L-2 EAD is not due to the I-765, it's due to the I-539. So for those I-765, that's the actual EAD application. For those applications that have their own biometrics requirement, like for the DACA deferred action applications, those are the ones that they will process without new biometrics. The I-539 biometrics, nothing has changed. All they've done is cancel all the biometrics notices and say that they will reissue those, reschedule those appointments once all of this is over. But this just keeps getting extended. So we can imagine the I-539 processing times are going to be delayed, which is in turn going to delay the I-765. So I wanted to work on a blog post today, did not get a chance to get it out, but hopefully tomorrow I will be able to do that so everybody can urge your congressman, your representative, your senator to tell USCIS to waive the biometric requirement for the I-539. It makes no sense why it's okay for them to do it for DACA kids and not for the legal immigrants who've done everything correctly. So that we need to have a big media push for that, I think, so that we get equal treatment there and we can get these applications processed without the biometrics.
Yeah, all we're telling is to treat the unlawful people and lawful people to be equal, and that's all we're requesting in this one. Emily, furlough, reduction of hours and reduction of wages, is that allowed for the non-immigrant visa people? I'm speaking about H1s, L1s, E1s, E2s?
Yeah,
E3s?
Unfortunately, like we talked about, the immigration regulations, the Department of Labor regulations, which govern wage and hour for the non-immigrant visas, they have not relaxed at all. So if you are in H-1B status, you are subject to the labor condition application requirements, the LCA, which is required to follow the prevailing wage provisions. So if any change to your terms and conditions of employment is being made that's not in accordance with the LCA that you have, the only way that change can be made is by first filing an amended petition. So they cannot reduce your hours, they cannot reduce your pay, or put you on furlough without pay without impacting your status. They need to be filing an amended petition for that. Same thing for L1s. The I-129 form specifies that you're going to work full-time and what your salary is going to be. There's not really a way to just reduce someone's pay when you're on a non-immigrant status.
Emily, what would you do? I mean, if you are an employee and Reddy Neumann PC says, and you're an employer of Reddy Neumann PC, you're on H-1B, what would you do? Or you're on furlough for 1 month?
Well, I guess I would have to explain to my employer that that's
Is
not
it a
an
violation?
option.
Is it a violation you are doing? Is it a violation employer is doing?
Both, because the employer is not in compliance with the wage and hour provisions. Technically, you could file a complaint against that employer. Now, would I recommend doing that to your existing employer who you're relying on for your future job? Maybe not right now, but I think a lot of, this is just new territory for everyone, and a lot of people are just unaware of the overall unintended consequences of telling people you have to stay home or work from home or not work at all, no pay, all those things. No one thinks about what that does to the legal immigrant population. And so employers need to be educated on that and understand that they can't just unilaterally take this action. It may require an amendment to be filed first.
I may have to say that if you get furlough, you may have to consider that as the 60-day grace period you already started. We have seen a lot of rumors that are circulating around. These are all the things that have been petitions that have been circulating. And they're telling people, pass this on to all the members. I mean, those are petitions that you're getting, and they're pointing out, look, it says that 60-day grace period has been extended. You don't read the full thing. It's just a petition. When you request somebody, that doesn't mean that it happens. When you request somebody and that person grants it, it may happen. Right now, this government is busy doing a lot of other things. Immigration is not on their top priority. We don't know when the government resurrects and comes into Act 2 how they are going to act. We yet don't know. I mean, this is completely unprecedented activity. What's going on in the world right now? I have never seen this one. Oh, by the way, this is going to be our 23rd year. On April 1st, 1997, our organization has been formed. So on April 1st, which is actually tomorrow, April Fool's Day, is our 23rd anniversary for Reddy Neumann PC. We have never seen these kind of things before. Believe me, it has never. I mean, this is a different war. So there are a lot of unprecedented things that are happening. Keep coming to the YouTube and Facebook. We will update you every week. But at this point of time, there is no regulatory changes with regards to the furlough, reduction of the wages, or reduction of the hours. It's not legal for the non-immigrant visa people. So you may consider that as a 60-day and plan your things accordingly. When the things are going to come out, you may have to leave the country and come back when the economy becomes very good. Emily, on the unemployment benefits, that if you get laid off, you're allowed to apply for the unemployment. Who are eligible, who are not eligible, and why are some of the people who are not eligible, why they're not eligible?
Yeah, so most of the non-immigrants that are in a work authorized type of visa, like H-1 or L-1 or TN, for example, are actually paying into unemployment, or their employer is contributing to this unemployment insurance, but you're not actually eligible to use it. The reason for that is, to be eligible for unemployment, you have to have an unrestricted right to work in this country. And for H-1s, L-1s, TNs, E-3s, your right to work in this country is restricted only to the employer that sponsored you. And if you lost that job, you don't have the right to continue working here. Therefore, you're not eligible for unemployment benefits. The major difference would be for H-4 EAD holders and
L-2
L-2 EAD holders. You do have an unrestricted right to work. Now, in that situation, if you have lost your job, but your spouse is still working and maintaining status, and your EAD is not expiring, you would be eligible to use unemployment, and that is not considered a public benefit for the purposes of the public charge rule that came out in February.
And so and also if the H-4 EAD is expiring and L-2 EAD is expiring, and you go to the State Department, State Workforce Commission, and say that you are eligible, you apply for the unemployment benefits, make sure that you only request the unemployment benefits until your EAD expires. You cannot request unemployment benefits beyond that period. And when you are filling any of those forms, please read those things very carefully. If there is at any point of time it tells you that are you a US citizen, don't take it. It's going to have a major impact. It's going to create a lot of problem for everything. If you have any of those things, I would rather want you to cut that, screenshot, take a picture of the screenshot, send it to us, let us take a look into it. We have cut down our prices to 50% for consultations for the next until April 20th. So if you want to, we are giving a very discount price you can do with us. And most of the other lawyers are also doing it. Don't click any box but you don't read it carefully, especially the unemployment benefits. You're dealing with the State Workforce Commission. Now there are 50 states, so all different laws are there. So I want you to read very carefully. Don't click any of those boxes if you don't understand it. So at this point of time, we are fine if you are an H-4 EAD and L-2 EAD to file the unemployment benefit. We're absolutely not fine. And you, if you lost the job, if you are an H-1, L-1, E-1, E-2, you should not file for the unemployment benefits.
Also, we've been getting a lot of questions about that CARES Act, the Coronavirus something Relief Act. Sorry, it's slipped my mind. But for these stimulus checks that the government plans to mail out, we talked last week about these are specifically, you're eligible for it unless you are a non-resident alien. Most work visa holders are resident aliens for tax purposes, and that makes you eligible for it. However, there's been a lot of question about what if my tax filing status within my household is mixed? What if I'm an H-1 holder and I have a social security number and filed as a resident, but my wife is on H-4, does not have an EAD, and filed using an ITIN instead of a social security number? Back in 2008, 2009, when we had the previous stimulus, people in that situation did not receive the stimulus. So that has now led us to believe that they might be following the same this time around. We don't have a specific guidance or update on that yet, but that may be a difficulty for some people to receive it, even if you are considered a resident alien.
Let's go to the questions, Emily. And the YouTube is Ankit has this question. He's 240-day extension. His I-94 is expired. He's in extension. He knows that he can stay in the country. His question is, can his wife continue studying on the H-4 visa? Absolutely. She can continue studying on H-4, no problem, even after the 240-day expires.
Mayur from YouTube asks, is the H-1B maximum period of 6 years, does that also include time spent in L-1 status? So if someone has already had 2 years in L-1, will I only get 4 years of H-1B? Yes, that is correct. L-1 time is counted towards H-1B time. Now, if you eventually get an approved I-140 and you are subject to the backlog, then that 6-year limit is no longer applicable. You can continue extending the H-1 beyond the 6-year limit, even if you've already used up a lot of your time while you were in L status.
Pallavi has this question. She lost the job. Should she wait for 50 days to file for the H-4, which she is eligible for? Or should she file it right now? And how is she going to get back to the H-1B visa later on? I would recommend to wait until 49th day to file for your H-4 EAD. There is no need for you to hurry up on filing the H-4. The way to get back to H-1B once you file the H-4 is you have to file a change of status application back from H-4 to H-1B. And if you have the remaining period of 6 years, or if you have an I-140 approval for more than 6 months, you're definitely eligible for H-1B if either of those two conditions met. You have to apply for the H-4 to H-1 status again. Here is a problem what will happen. When you apply for the H-4 and then when you get a job after a while, let's say for example, 4 months down the line you get a job and you want to file a H-1. There may be a problem. They may not issue a H-1B approval with the I-94 because in between you are in H-4 and that H-4 does not get approved. So you have two options. One, you can join the litigation that we do. The second option, that maybe easier option, is when you file a H-1B, the best option maybe is that the company can file a consular processing. They can get once the H-1B is approved, you can step outside the country if you have a passport stamping, or you can just go to Canada or Mexico, get the passport stamping, and then come back into the country. So that difficulty is not to move to H4, but coming back from H4 to H1. You may have to step outside the country to come back into the country.
Tripti from Facebook wants to know, since physical therapists are considered essential workers, shouldn't they be given a green card based on this? It's a really good question. Unfortunately, our government just doesn't see things that way. In addition to physical therapists being essential workers,
Nurses.
we have 6% of all doctors that are dealing with this coronavirus situation are foreign-born doctors. We have thousands of DACA holders who are working in the front lines during this pandemic. So it's very difficult to make an exception for one group without thinking about all the different people who are involved in this. Physical therapists and nurses both do have a special green card process under the Schedule A that allows you to skip the labor certification process, because we've known for years that there's a shortage of workers in that occupation. But that's as far as the government's willing to go as far as offering people green cards based on essential workers and specific needs based on everything that's going on right now.
You raised a very good question, is that there is a possibility that the government may come and relieve a lot of these people and give them the green card. So we have seen that when there was a war and there were not enough volunteers, they have picked up all the non-immigrant visa people who volunteered for the wars, volunteer for the military services. They have given the citizenship directly. That was called Manvi program. That's scrapped right now because recently Obama administration and Trump administration started pulling back the troops from outside the country. Now, I think so, we are at Third World War. I mean, the only difference is that it doesn't look like the soldiers tend to take the guns and shoot the people down. I mean, shoot the enemy down there. It looks like the nurses, physical therapists, doctors, and the healthcare workers might be the people that we need to combat this World War III. So there's a possibility they can do some benefits. You probably might have to lobby this one, not right now, once this is over. Even once this is over, we will have the scars of all these things, because even if COVID-19 is over, now we have scared, what's going to happen? Maybe something else come in and the name will be XYZ0245 might come in and it might scare us all. So yes, healthcare workers might be given importance. It looks like the entire world is turning to them right now. And we are thinking that back in olden days when soldiers used to walk out and we used to go clap for them and do all those things, we're doing the same thing for healthcare workers. So there is good possibility that Congress may act, and you may want to contact the congressman on that.
Sudhir from YouTube wants to know how long I can stay here after applying for an H-1B extension to recapture 2 months of time. So just by filing that extension, that does not allow you to stay beyond the 2 months that you are asking for. So if your extension is asking for a 2-month period and you don't have your I-140 approved by the end of that 2-month period, you have to leave the country at the end of the 2 months, even if the extension is still pending. So just having a pending extension after you've run out of time does not allow you to stay beyond the 6-year limit. So your other option would be to file a change of status to B2, or if there's some other visa category, I have a couple of people in the same situation that are filing a change of status to H4, where their spouse is in the US. But you can't rely on a pending extension just because there's long processing times when you don't actually qualify for that extra time.
Mohammed from YouTube has this question that his green card interview has been postponed because of the COVID. When will the USCIS be back, when he is going to get the interview? Well, we don't know how much this lockout period will stand. I wish I can tell it. We have to keep watching the news. We will be coming every week. Right now, until next Tuesday, that we are going to be live on, definitely doesn't look like USCIS is going to call you. When they come back, it may take a long time for your turn to come, because they will try to process the things that are very urgent. You may not be on the top of the list for them to adjudicate their application. When the USCIS is going to fully come back, it might take a little bit of time. So I would want you to be prepared for about 6 months period. at least, assuming that in the next 2 months things are going to be cleared up.
Sahil from YouTube wants to know what other visa options are available for someone who doesn't get selected in the lottery. You know, so many people now have been trying 3, 4, 5 times in a row and are not getting selected. So, you know, all we have are the available letters of the alphabet for the visas. So you have the L1 option, which would require you to work outside the U.S. for a affiliated company to your U.S. company for at least 1 year. If it's in a specialized knowledge capacity, they could bring you back into the U.S. on an L1B. Or if it's as a manager or executive, they could bring you back into the U.S. after 1 year in an L1A for a manager or executive position. Those aren't necessarily easy to get. Just because you've worked outside the U.S. for 1 year doesn't mean you automatically qualify. USCIS strictly looks into the foreign position to make sure you truly used specialized knowledge, you have the training, you have the background, or you truly were a manager or executive, and that the U.S. position also qualifies as specialized knowledge manager or executive. So L1 has become more and more popular. And there's no cap on it. You can file it at any time once you meet the requirements. J1 trainee may be an option. There are certain agencies that your employer can work with in order to have the agency sponsor the J1, and they place you at the employer's location. It's not a work visa. It is for on-the-job training. It's a trainee, similar to optional practical training that you get at the end of F1. So that may be an option. It's only the maximum amount of time available is 18 months, so it's not a good long-term option, but it might buy you time to try next year in the lottery. O1 is also an option, but it is not easy to get. It's meant for you know, exceptional, extraordinary ability. It's very similar to the EB1 green card category. Other than that, you know, you're looking at if your spouse is in H1, you have the option of the H-4 and EAD. If your spouse has the I-140 approved, I mean, all of this to say there's options, but they're very limited. The H-1 is generally the go-to work visa for most people, unless you're from a country that has the option of the E-visa for treaty trader or investor, or TN like Canada or Mexico. Those are about it at this point.
Oh, why can't I get day one CPT? I can go to college and just enroll there and pay them the money and they give a CPT immediately. Why can't I do that?
Well, I mean, and you know, we've talked about these day one CPT schools for quite some time. We're both of the opinion that they're one step away from University of Farmington, which was a fake school created by ICE to entrap students. We think that these schools are not following the regulations, are not properly authorizing CPT. USCIS agrees that they're not properly authorizing CPT, and they end up denying the change of status to H1 later. And then once you leave to try to get the H-1B visa stamp, they're denying the visa stamp, saying that you've misrepresented something to the school or to the SEVIS system, or you know, they're coming up with all these reasons why you're not eligible for the visa because of these day one CPT schools. So we definitely do not recommend that.
Having some experience with regards to the previous 2 recessions that I, as an immigration lawyer that I've been practicing from 1997 though, the interpretations, the enforcements right now, what it is in USA is much more stricter than what it was in 2000, 2001, or 2008 and 2009. What I would recommend is that if the things do not work for you here, I would want you to plan, of course, obviously not swim from here to there when the things are permitted. If the things, you know, if economy is bad, I would want you to plan to go to your home country, stay there, and try to come back when the economy becomes better. Otherwise, if you try to do anything illegal activity or a risky activity, what will happen is that you will be permanently barred coming back into this country, which you don't want to do that. Either joining the day one CPT or doing any other activity is very dangerous for you. We do not advise you do that thing. I would rather want you to advise go to your home country. There's a good chance with all these things, you know, things may, you know, I've noticed that in 2008 and 2009 things picked up. in other countries first, and then it picked up here. So you may want to consider going back and then coming back. That will be a much better way of doing.
Hemant from YouTube is on H-1, and his wife is also on H-1, but recently lost her job. He's planning to apply for a change of status to H-4 for his wife, but knows the processing time is close to 8 months for that. Wants to know what are the options if she later does get a job offer for her to change back to H-1 if that H-4 is still pending. So you can file a change of status back to H-1, but you cannot start working until that H-1 is approved with the I-94 card. And if the H-4 is still pending, it's very likely that your H-1 will be approved without the I-94 card. So typically what you would do if your H-4 is still pending is file the H-1B, possibly requesting consular processing. As soon as it's approved, you exit the country, get that visa stamped and come back in, and now you're back in H-1B status.
Anurag has this question: can he on H-1B go back and stay at his home country, and can his wife stay here on H-4? Can he start? Can he work in his home country and wife here on H-4? Stay here and continue working, or staying in this country? Anurag, no. When you go to your home country and stay there, it's considered that you're not maintaining the H-1B. And since you said that your project is over and you're going to your home country, that means you're not maintaining the H-1B. If you do not maintain the H-1B, your wife cannot stay here on H-4. She has to leave the country. She cannot continue working here.
Gautam from YouTube has a question about H-4 EAD that's expiring in December and knows that you normally can only apply for the extension 180 days in advance, but her spouse's H-1 has a material change and is planning to file an amendment and wants to know if the H-4 EAD extension can be applied early along with that amendment. Yes, we've done that many times in the past, filing the H-4 very, very early, the EAD, even a year, 2 years early. Just like filing a transfer, the same thing. You can file the H-4 EAD extension early as long as it's filed with an H-1 to get that longer validity period and not have to worry about your EAD expiring while you wait for it.
Venkat has this question. He's an H-1B. He's planning to invest in the stock market. Is that going to create any problem because he's an H-1B? No, sir. You have no problem in investing your money in the stock market. You are perfectly legal because that is not considered that you're working. Investment is perfectly allowed, and stock market is absolutely investment. Nobody can tell you that you're working, so you're perfectly good to do.
Alvina from Facebook has an H-4 EAD that's expiring in May. Had the biometrics appointment scheduled for today, but of course that's canceled because the appointment service centers are closed. So she wants to know, this is her first EAD extension after the biometrics began for the H-4, and the last time the biometrics were done was when they applied for the visa. Can they use those biometrics for processing this H-4 extension with the EAD? So the announcement that came out yesterday would suggest no, they're not going to do that. They're only using the biometrics that were from a previous I-765. The H-4 and the EAD biometrics are from an I-539, so it's not part of yesterday's announcement. On top of that, the fingerprinting that you did outside the country is a different government agency. That's the Department of State. Your current H-4 and EAD application is processed by Homeland Security, a different agency. Very unlikely that they're going to share information about these biometrics to help people through this time. So that's where I think we're going to have to contact our representatives and ask them to urge USCIS to allow the biometrics to be waived for the I-539 during this time period.
Kumar has this question. I see some people posting that they got their H-1B selected 3 or 4 times in the CAP subject in the lottery. Is the USCIS going to make any effort in curbing these things? Yes, Kumar. We have seen significantly so many times USCIS coming and arresting some of the employers. However, though, in the 2020, we feel that it's not going to be limited to only employers. They might actually detain or probably deport some of these employees also for collaborating with the employers. We do have some information that there are some setups done by the ICE and USCIS to trap the student visa people who wanted to apply in a duplicate H-1B when there is no job whatsoever at all. I do believe that they are going to be revealed pretty soon, and they will, like the way what happened with the University of Farmington, one night they will come to all 600 people and detain them and then put them in the detention. There is a good possibility that these people who don't have jobs, who have applied, we know those companies, we know those people who don't have jobs and apply. It's so easy to figure it out. It doesn't take much time. Thinking that the USCIS does not know that is the stupidity that they have done, and you will see the consequences pretty soon.
Chaitanya from Facebook wants to know if taking the COVID-19 stimulus check will have an impact on green card prospects. That's a really good question. So although this is put in terms of a relief check and you feel like you're getting free money, it's not a public benefit. This is actually a tax credit for your 2020 taxes that they're giving you now instead of making you wait until you file your taxes in April of 2021. So you're not really receiving free money or anything like that. It's just a tax credit, just like you would get a tax credit if you contribute to a 401k or an IRA. You are reducing the amount of taxes you have to pay by doing that. Just like when you pay college tuition, you get a tax credit for that. This is not a public benefit. It's not meant to be income maintenance. It's just a simple tax credit that you're getting early.
Emily, I need your attention on this one. You said that in the H-1B lottery, and there are two questions coming out, one from Ram Prasad and also one from Nitin Rao from Facebook. You said that there are two things right now in the lottery system. One is selected, that means that they can file the H-1B, they're good to go, no problem with it. The other one is still saying submitted. I mean, it doesn't say it's not selected yet. You said that maybe they have to wait until September 30th of 2021 to figure it out, they need to file it or not. Because there may be some people that might not apply who are being selected in the lottery, and that might exceed the number of what USCIS has thought, and they may reopen, and the percentage you said is between 1 to 3% is what you and I were debating about on the chances of it. But why would it wait until September 30th of 2021? Would we not figure it out on June 30th of 2020?
Well, potentially, but we don't know, if we're basing this on how many petitions are actually filed, that would make sense. On June 30th, they'll know how many petitions are filed. They have no way of knowing how many will eventually be withdrawn if the economy goes downhill and employers filed by June 30th but change their mind before October 1st and withdraw, or the rate of denial has been going up every year the last few years. So think of it as back when the economy was not great, the cap used to stay open. I mean, I remember one year it was open all the way till December. It just never got filled. And so just because we cross October 1st or just because we cross June 30th, if the cap's not full, we could keep filing, and this is the same idea.
So most probably by June 30th we should get one more lottery and maybe continue further depending on the economy.
I mean, I would say if there's going to be a second lottery, we should know by June 30th.
Okay.
But
you still, these are very unprecedented circumstances that we are going through. I mean, normally, we tell a joke, when the sky is going to fall down. I mean, this time I think so, sky has fallen down. I mean, that's what I think so. So, yeah, the economy, the way things are turning around, yeah, it could be we will get a good picture on June 30th. We could have more openings coming up and may stay until September 30th. Technically, they can keep this lottery open all the way. I mean, the the window to be open all the way to September 30th of 2021.
Arun Deep from Facebook wants to know, what is the grace period to file a change of status for someone on a TN and a TD after losing the job? It's the same 60-day grace period. So within that 60 days, you would either need to find a new employer and file a TN transfer, or go to the border to receive the TN transfer, or file a change of status.
Shayes from YouTube has this question. He's applied for B2 because he's maxing out on April 3rd. How long will it take for his B2 approval? Can my employer fire me after April 3rd? Well, your employer doesn't have to fire you after April 3rd. You're automatically out. He can't keep you employed, period, because he cannot employ you. So it's not considered as firing. I mean, it's out. I mean, you can't work for him, technically. Second thing is that the B2 is going to take, it might take anywhere between 4 months to even 12 months for you to get the approval. I'm assuming that since you filed this B2 because you can't exit on April 3rd, because the only way to exit is take a swimming suit and go swim across, which you cannot do it, I'm assuming that you're going to leave the country when the things are going to get better in the health-wise, where travel advisory is be allowing you to go to your home country, and the airplane, the flights are resumed. If both of those things occurred, I'm assuming that you're going to leave the country. But if you are planning to stay until the B2 is approved, I would not recommend you stay there, because you may have to check with your lawyer. What's the purpose for you to stay here for that long period? You only filed here so that you cannot exit on April 3rd. You should leave the country. If you were to plan to stay, you should consult a lawyer.
Balakumaran from YouTube wants to know, when is an amendment required for someone who needs to work from home? So an amendment is required when a material change in employment occurs for H-1B holders. H-1B holders are subject to the LCA requirements, and the LCA, a new LCA is needed if you are going to work in a location that was not contemplated on the original LCA. That means you're going to work in an area that's outside the metropolitan statistical area of where your LCA is. So if your LCA is for you to work in Houston, Texas, downtown, for example, and you live in Cypress, Texas, which is a suburb of Houston, that's still within the same metropolitan statistical area, and it's not considered a material change because no new LCA is required. An existing LCA for Houston covers Cypress. However, if your LCA is for you to work in Houston, but you actually live in New York and you're going to work from home in New York State, that is not in the same metropolitan statistical area. That would require an amendment to be filed unless the short-term placement provision is met, and that can allow you to work for up to 30 days at a different location that's not specified in your LCA if certain conditions are met. There's a really good fact sheet on the Department of Labor website about how the short-term placement provision works, but if you're staying within the same general area of the location on your LCA, an amendment is not required.
Is there a hidden algorithm for the H-1B lottery? No, I don't think so. It will be there, because all these things will be subject to court cases and legal requirements. If anybody does anything, it will be considered, I mean, having something where they rigged the H-1B lottery system, that is a crime, even if the government officer does it, and some government officers have to be indulged in it, that will be a crime. I don't think so there will be any hidden algorithms. I know some people will say, well, you know, one company filed 8 H-1B cases in master's quota, only 1 got approved, one company filed 10 of them, all 9 got selected. It's just random, and it's just a lottery. I mean, you know, there are 235 million people who buy it, and I do buy that lottery too. I don't get it, somebody else get it. Why did that guy get it? I did not get it. Well, I don't think so. There is a hidden, it's just a chance, luck chance, that's all. Another question from Mayur comes is, on L-1B, am I eligible for EB-1C category? you could be eligible. You could be eligible for EB1C category, but we need to look very carefully whether the position for which you have been hired back in your home country, does it qualify to be a multinational executive position. Now, you are not in a multinational executive position right now, but if the company that you're working for, will it offer you a multinational executive position? If both the conditions met, you may be eligible for EB1C. Certain times what we do is, instead of converting into EB1C, we normally will try to do the test, we call that as testing waters, is to try to convert L1B into L1A to see if that works. And if that works, then we will convert it to EB1C.
Tishbeer from YouTube was laid off from a CAP-exempt H-1B job yesterday, but the CAP subject H-1B was selected in the lottery for this year. So he wants to know, how can I maintain status until October 1st? Well, the CAP subject H-1B is not going to kick in until October 1st, and your CAP exempt H-1, you basically have the 60-day grace period. So unless there's some other visa category that you qualify for, you're not going to be able to stay beyond that 60-day grace period simply because you've got the H-1B pending in the lottery that will start on October 1st. You could potentially, file a change of status to B2 for that interim period, but it very likely is not going to be approved by the time your H-1B needs to kick in on October 1st. So your H-1B may have to be for consular processing, and once it's approved, you go out, get the visa stamped, and come back in to regain status on October 1st.
Emily, can you have a template on your blog? A request comes from Ram, that a template of letter requesting the congressman to waive the biometric requirement.
Yes, I'm going to be working on that. I was hoping to have it posted today, but did not get a chance.
Emily, what about the lawsuit that we are filing this Friday, that we are challenging the USCI? We are challenging the USCI's decision with regards to why do they need the fingerprints on the H-4 EAD? This Friday we are filing the lawsuit, is right?
That's correct.
We are filing a lawsuit this Friday in the Washington, D.C., challenging their decision, why you need a fingerprint notice for H-4s and also for the L-2s. We will be filing that lawsuit on this Friday. It's part of the litigation that we are filing, but also Emily will try to post that thing on she's going to post that on the immigrationgirl.com.
And Ram from YouTube wants to know, after at what point can you file the litigation after the H-1B extension is approved? So once the H-4 and the EAD have been pending for 30 days, you can join in any of our upcoming litigation. We file it every 2 weeks. So our next one is April 3rd. We're not accepting new cases for that filing right now, so we would be accepting next week for the April 17th filing. All we require is that the H-4 and EAD be filed at least 30 days previously.
Krishna Mohan from YouTube asks this question. The B2 is expiring. Is there an exemption for the people to stay in the country beyond the expiration date? Well, it is expiring, but you don't have to file a physical application. The COVID and all these people are advising, like stay at home and other things. But there is nothing that is prohibiting you for you to file an online B2 extension online. It's online. I mean, you don't need to go anywhere. You don't need to meet anybody. You don't need to get out of the home. You can file it. So I do not want you to just sit down and do nothing. I want you to file an online application called I-539 to extend the B2. Otherwise, there will be consequences for the passport stamping that you have is considered to be invalid. There are other negative consequences. You don't want that to happen.
Matthew from YouTube has an H-1B extension due soon, but also involves a location change. And so the company is going to be filing a new perm labor certification in I-140 because of this location change. He wants to know if that new labor or I-140 process is going to cause an issue for the H-1B renewal. Generally, no. So once your I-140 has been approved, if it's been approved for at least 180 days, it remains valid for you to use it for future H-1 extensions. So you can keep using your original I-140 approval while the new I-140 process is underway. It should not have any impact on the H-1B.
Srinivas from Facebook has this question, are there any travel restrictions because he's going to file the H-1B in the lottery, he got selected in the lottery, I'm assuming, and you're filing in the consular processing? Yes, there are a lot of restrictions on the travel because if you are filing in the H-1B and you're trying to come back on any other visa into this country, you may be sent back in the next flight. That happens. Recently, we have seen a lot of enforcement in by the CBP officers at the airport. We may see more of those enforcement if you're trying to come back on any other visa while your H-1B is pending. The reason is that when you're, let's say for example, if F1, if you're coming into the country, you must have an intention only to come temporarily, and after that, you have to exit outside the country. But you have on the contrary to that one, you have a H-1B petition pending there that tells that you want to work on a long time here. So we would not advise that you travel. The second thing why I do not advise consular processing is that technically you're not counted towards the H-1B number, though you have been selected towards the H-1B number on the lottery, though if your H-1B gets approved also, you're technically not counted toward the H-1B number unless you go outside the country and get the stamping of the H-1B. So you're actually taking more risk there to have your H-1B counted. Instead of two-step process, you're going three-step process. So that's the reason to avoid that. I would recommend that you file a change of status and don't travel.
Edgar from YouTube, his wife's H-1B is expiring in September, but her perm is still not approved, and he's not sure if she'll be able to get the perm and I-140 approved in time before she runs out of H-1 time, and she did not file the perm 365 days before the 6-year limit. So what options are available for her? So normally when we're not under travel restrictions, I suggest people to take strategic vacations or business trips outside the U.S. Because you can recapture any time you spent outside the U.S. and apply for an additional extension in the hopes that that will eventually buy you enough time to get both the labor and I-140 approved so that you can then extend the H-1B. So that's kind of the most common option. Otherwise, exiting the country and waiting until the 365-day period has been met, and then a new H-1B petition can be filed to request a 1-year extension from outside the U.S. based on the fact that the perm was filed more than 365 days ago, or filing a change of status to any other type of visa category that you qualify for until you meet the requirement to be able to extend the H-1 further.
Pallavi has this question from YouTube. Is the H-4 status counted towards the 6 years of the H-1B timing? The answer is only one word: no. It's not counted. Even if you are on the H-4 EAD, that period is not counted towards the H-1B. Darshan Pathak has this question: how to check if the I-140 has been approved for 180 days and not been withdrawn? Now, everybody who gets their I-140 approved, I will tell them easy way called, you can file a thing called FOIA, Freedom of Information Act. You can go to USCIS website. It's so easy to file it. If you file it normally, you will get your I-140 information between 30 to 60 days. Of course, nowadays it'll take a little bit longer time because of the COVID situation, but you can file it online and it will tell you when your application has been withdrawn. A lot of lawyers will ask that. Just because you show the I-140 approval, they are not satisfied because they don't want to spend all the money and get your H-1B denied. They want to see this one. So if you ever left a company that filed your I-140, I want everybody to go online, USCIS FOIA, put that in the Google, fill that application. It's online, it's free, you can do it by yourself, you'll get that information.
Kishle from Facebook wants to know, can we keep using an employer's approved I-140 for H-4 EAD extensions after we've left that company if the new employer has not yet started the green card process? Yes, so as long as that I-140 was approved for at least 180 days, you can keep using it for your own H-1 extensions with any employer and for your spouse's H-4 EAD approval extensions, even if you have not yet started the green card process with your new employer at that time.
One question that comes from Vicky is that immigration attorney firm has been too slow. His H-1B is expiring in June. Despite follow-ups, what can he do? Well, Vicky, right now, unfortunately, the premium processing is suspended. However, though, June is a long period of time. They should be able to file it. If they file the H-1B before June, you can continue working in United States after June of 2020. Absolutely, you can continue working, you can stay in this country. Obviously, we used to tell everybody to get their result before their I-94 expires so that they have a second chance if by any chance they get a denial. But now, since the premium processing is suspended, that's going to be major trouble for you. You have, you're locked up right now. You'll have to wait. You just file for the extension, wait for the premium processing to come, and try to convert into premium processing.
Suma from Facebook wants to know how you can maintain status if the H-1B has been filed in the lottery, but the STEM OPT is expiring prior to September 30th. So this is where the cap-gap automatic extension comes into play. If your OPT or STEM OPT is expiring between April 1st and September 30th, and your H-1B has been selected and it's been filed, as long as it requests a change of status with an October 1st start date, once that H-1B is filed, you can go back to your school and request a cap-gap I-20, and that will you can show that to your employer to show that your employment authorization has been automatically extended to September 30th. Now, if the H-1B is still pending on October 1st, that cap-gap work authorization ends. You have to stop working from that date until the H-1B gets approved. So hopefully processing times for the cap cases, we have enough time to get them approved, or hopefully premium processing will be back so people don't end up in that situation where you have to stop working on October 1st.
A good question that comes out is that my 60-day max out because I lost the job is coming nearby. What is the best option? Is B2 better option, or is it F1 better option? And how can I come back to H-1B visa though? Now, at this point of time, it is absolutely only B2, not F1. The reason is that under the current circumstances, you can't leave the country, so obviously you can apply for the B2. F1 requires that you maintain the status until the F1 is approved, which may take anywhere between 6 months to 18 months. Since your 60 days is expiring right now, you can't get an F1 visa. So that is completely ruled out. Now, B2 is a good option right now. You can file a B2. But one problem with a B2 is to come back onto H-1B is a thing which most probably could not be achieved. If you have any plans to convert into B2 and then come back into H-1B, I would strongly recommend that you consult a lawyer. Now, the B2 is only you file temporarily so that the things get cooled down where you are allowed to travel. That's the only reason why you will be. My advice is to file a B2, wait for the things to calm down, and then so you can travel to your home country, and then apply for the B2, and then while you are in your home country, apply for the H-1B and come back into the country.
Sarvesh from YouTube has an H-1B that was submitted, the registration was submitted and is currently on STEM OPT, but has been furloughed until April 20th and wants to know if the H-1B petition gets selected, can it still be filed? So we do have that filing window through June 30th. So if your employer, notifies you that you're selected, and that job becomes available to you again before June 30th, they can absolutely file the petition on your behalf still, even if you've been furloughed in the month of April. Just make sure that furlough, you need to basically treat it as unemployment time, so you can't exceed your OPT unemployment time. Be careful of that so you can continue to maintain your F1 status.
Savvy from YouTube has this question. Can the renewal applications still be sent to USA? Are they closed? Are they open? Right now, we can still send the application to the USCIS. That meets the burden of meeting the deadline. We are still filing the cases in our office with very limited circumstances. So obviously, urgent cases, we are filing them. Are they opening those things? We're noticing, we have been informed that they may not be fully functional at this point of time. Another question from Vivek from Facebook comes in. Are the application support center be closed after 6th April 2020? All indications seems to be very clear that the application support centers will be closed even after April 6th of 2020. If there is any changes, we will update you in the next week, Tuesday at 5 o'clock. Emily, anything else?
I think that's about it for today. Thank you so much for joining us. We hope you find this information helpful, and we'll keep doing it every week. If we did not get to your question, or if you'd like further information on your specific situation, as Rahul said, we are offering discounted consultations right now because everyone's kind of in the same situation here. So you can go to rnlawgroup.com and click on consultation for the details for that. We do also offer a free conference call every day. You can call in to ask your questions there, and that is also, the schedule is at rnlawgroup.com. And I'll do my best to get a template letter posted on immigrationgirl.com for you to urge your representatives to try to get this biometrics waived for H-4 EAD extensions right now.
Thank you very much.
Thanks for joining.